Wednesday. It's Mandy V, and I'm here for another week of Tuesday Tips. That's right, this week it's on a Wednesday. If you like this and my other tips, please subscribe so you'll get new uploads each week. Also, be sure to comment below what other topics you'd like to see covered. Now, let's get to it. This week with Taylor Swift, we witnessed the heartbreaking reality of what happens when you don't control your master recordings and music. Her catalog of music with her former record label was sold to artist manager Scooter Braun, who Taylor Swift says bullied her and that the owner of the record label knew it. Masters, of course, are the original recordings of songs. Artists and songwriters are generally the original owners of the masters, but when an artist signs a contract with a record company, they almost always sign over their rights in exchange for an advance. Depending on what type of leverage they have, the duration of the master's ownership can be set for a number of years, a number of albums, or in perpetuity, which means forever. Now, I don't know the terms of Taylor's contract, but it's apparent it wasn't based on a limited number of years. Now, with ownership over the masters, Scooter stands to chance to benefit greatly off her work. He will now receive royalty payments for any music from that catalog used for couplings, compilations, box sets, television commercials, DVDs, printed music, motion pictures, video games, webcasts, podcasts, and more. I can't imagine the level of betrayal and anger she must have felt knowing that the music she spent days and nights writing and that catapulted her into the fame she now enjoys will now be in the hands of her nemesis. No doubt she had a sentimental connection to that music, but this is why it's so important to have some level of control over your masters. The first way to exercise more control over your masters is to negotiate reasonable terms before signing a contract. Be aware of any terms that might appear in your contract, such as a long rights period for the record company. Options over future recordings, such as that the record company can automatically get rights over future recordings in return for paying a cash advance. And an exclusive recording agreement, which is that every recording created during the term of the agreement is owned by the record company. In order to ensure the contract is carefully scrutinized, make sure to hire someone with trained eyes and a wealth of knowledge about music, contracts, and who's going to review every document presented to you. Although the opportunity to get your hands on that immediate advance money record labels present to you can be very tempting, please consider that you stand to earn much more by retaining ownership over your own masters. If the terms of the contract are not reasonable, please don't sell yourself short of a windfall of income you can earn in the future. There are alternatives to signing contracts. First, you can consider licensing your music on a case-by-case basis for a limited period of time. Second, if you have a record coming out or if there is a film that will be using your music, you can set up your own publishing company and register your music through the publishing company. Promote your music and pocket the publishing royalties all for yourself. In comparison to having to issue licenses and negotiate deals individually, you'll get paid royalties based on the statutory rates. Here's how you can set up your own publishing company. Affiliate your company with ASCAP or BMI. Complete an application and choose 3 potential names for your business. The reason you have to do this is because the companies want to make sure your company name is different from any other names. So make sure the name you choose is not common. If you are also a songwriter, you should affiliate with one of the two societies at the same time. You can't register with both. An approval may take up to 5 weeks, so make sure you get the process started early. You can go to www.bmi.com for BMI or www.ascap.com for ASCAP. You need to set up your business as an LLC or corporation. If you don't already have an LLC or a corporation, or if you do have one but intend to establish your publishing company under a different name, be sure to set up the publishing company under the desired name with your state. Generally, you can find information about the process of setting up an LLC or corporation by visiting your state's Secretary of State website. Register the songs with the U.S. Copyright Office in the name of your publishing company. If they were previously set up under your individual name, you will have to file an assignment to transfer them to the publishing company's name. Register your songs with the Performing Rights Society with which you affiliated in Step 1. The websites will have detailed information about the process of registering. You can only register songs as the publisher or writer, but not both. After you've taken these steps, you can now issue licenses to potential users and wait for the royalties to come in. Again, we all know how tempting it may be to sign a piece of paper knowing that you will get a lump sum of cash up front. But please take into consideration the long-term impact. What do you stand to lose in the future? How long will the record company own your masters? Will you have a chance to purchase them all back? All of these are important questions you need to ask yourself. If you are uncomfortable with the answers, you need to evaluate the possibility of licensing or setting up your own publishing company. Thanks everybody for tuning in. This is Mandy V, and this has been another week of Tuesday Tips.